Thank you for joining us today for this session, Intellectual Property Protection and Invention Disclosure in Europe, Legal Strategies and Best Practices. This topic was chosen by a large majority of you through the survey we sent before the event, so we are glad to bring it to you today. Before we begin, I would like to share some quick information. The session will last 45 minutes. The first 30 minutes will be a presentation by Amber Nicole Roibu, a legal attorney specialized in intellectual property and patent law from Carter, DeLuca and Farrell, about the topic you choose to be more important. After the presentation, we will have a Q&A session. So please write your question in the chat during the presentation or after. Amber will read them and answer at the end. A few technical notes. All microphones will be muted during the presentation. The session will be recorded, so if you don't want your face to appear, you can turn off your camera. If you have any technical issues, feel free to write it in the chat and we'll try to help you. And after the session, we will send you the recording and some additional materials by email. So thank you. Amber, you can start whenever you are ready.
Thank you so much for the introduction and for having us today. My colleague George is also on the seminar. He's a partner at our firm. And thank you everybody for joining. Hopefully you'll find the session to be informative and just help answer any high-level questions you might have pertaining to patent filings in the US versus in Europe, and in particular how disclosures vary in the US and in Europe. And so on our agenda today, I would like to begin by just discussing the importance of intellectual property or IP, in particular as it coincides with your business goals, whether you're a startup or a bigger company or just a solo inventor. I'd also like to discuss what a patent is at large, as well as the benefits of US provisional patent applications and how you can overlap patent protection between Europe and the US, being strategic and using particular filings. We'll then transition into a discussion of EPO-specific patent procedures in Europe, as well as disclosure-related considerations as well. And then we'll wrap up with some key takeaways and best practices, and then we'll turn it over to answer any questions you might have. So first and foremost, why does IP matter? Well, from the very inception of IP, it helps protect your unique products, services, and technologies, and it ensures that competitors cannot replicate or exploit your innovations. Additionally, it provides you with the added benefit of brand differentiation, so the use of trademarks and logos and different branding elements that you might have associated with your product or your company help create a distinct identity in the consumer market and ultimately help your business stand out in the marketplace. And it builds customer loyalty, which is really beneficial. It also helps attract investors. So IP assets like patents or proprietary technologies can make your business more attractive to potential investors down the line. And it can help showcase your business as having valuable and defensible intellectual property that is worth investing in. It also provides a very great monetization opportunity, as intellectual property, for example, patents can be licensed or sold, so it can provide additional revenue streams that can help fuel growth and expansion and ultimately help you develop new products and services down the line. Now, what is a patent? So a patent provides you with the exclusive right for an invention, process, or product that is new, useful, and non-obvious, and I'll discuss what that means in further details. And so what this exclusive right provides you with is the right to exclude others from making, using, importing, offering for sale, or selling the invention within the jurisdiction where you have patent rights. So that could be the US, it could be Europe, it could be US and Europe. What it does not give you is the right to make, use, import, offer for sale, or sell the invention, as that would constitute a negative monopoly, and that is not the objective of the patent system. So in exchange for this right, you as the inventor provide the patent office with, first and foremost, a disclosure of the invention. And so it's released to the public, it gets published, it's no longer kept as a trade secret within your startup or your company. Additionally, you agree to release the invention to the public after the patent expires, which is generally 20 years from the earliest filing date of your application. And this is pretty much consistent across all major countries at this point due to patent harmonization rules that have been put in place. So it's generally speaking 20 years from earliest filing. So in the US, in order to be granted a patent, first and foremost, your application, your invention, your innovation needs to be new or novel. So it cannot be in the prior art, as we call it, which is those things that are already published or patented or that already have applications filed towards them. So it cannot already be publicly known. Additionally, it has to be non-obvious. So obviousness is essentially a measurement between the difference between what is in the prior art and what is claimed in the invention that you are putting forth in your application. And so the prior art, or what's already out there, cannot suggest your invention, and your invention cannot just be some obvious improvement on what's already out there. Lastly, your invention or the innovation that you're putting forth in your application needs to be useful. So it needs to provide some benefit to society. It has to have a real world use or application, whether it's in a particular industry or just at large. And so while these are US specific terms, these requirements are present in the European Patent Office as well. They just take different names. So you might see inventiveness used instead of some of the words that you see on the screen, but generally speaking, the requirements are the same. It has to be new, it can't be an obvious rendering of what's already out there, and it needs to be useful. It is important to note, and we'll go into this more detail later, unlike in the US, in Europe, you cannot get patent protection over surgical methods or methods of medical treatment, but you can get patent protection over medical devices. So what can be patented? This is kind of a convoluted question, and there's really not a very straightforward answer all the time, but there is statutory guidance that helps us, carve out exceptions and understand what is patentable. So in most countries, different ideas, concepts, discoveries, scientific theories, so on and so forth are not considered patentable. In order to be patentable, you have to invent or discover a new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. So again, something that is not just an obvious improvement on what's already out there. There are 4 statutory categories that are carved out that are exceptions. So these are things that you cannot get patents on. And so that includes laws of nature, natural phenomena, and abstract ideas. And so from the perspective of abstract ideas, you have to be very careful how you claim software and software-related inventions to avoid a rejection in the US under this statutory section. So generally speaking, we tell clients that if you cannot clearly explain the steps of the AI or the machine learning model or whatever other software algorithm it might be that you're trying to put forth, and its ability to ultimately solve a real-world problem, your chances of being granted a patent are very low because it'll be deemed to be an abstract idea and will fall within one of these exceptions to patentability. So now I'd like to briefly touch upon US provisional patent applications and the benefits, with filing these and what these are. So just to preface, in the US, we have a sort of 2-tier application filing scheme. And so you can start off by filing a provisional patent application, which is not examined by the USPTO and it's not published. So you can ultimately decide to keep your invention a trade secret because it will not be released to the public. And then you have 1 year within which you can file a non-provisional or a final utility patent application, and that will ultimately be examined and published. So this is a nice starting point to ultimately just get a stake in the ground at the USPTO and be allotted a filing date, which is very beneficial in terms of the amount of prior art or publications or patents that are already out there that can be used against you when you get to the point of examination. And so the US and all countries are a first inventor to file regime. In the US, we used to be a first inventor to invent regime, and that has since changed. And so, as I mentioned, provisional applications help you establish a priority date while postponing your decision to ultimately pursue domestic or foreign patent applications. Another added benefit is that it does not affect the term of your patent. And so it really is such a beneficial filing. We always encourage inventors to consider filing a provisional patent application first. It's also very low cost as compared to a non-provisional or a final patent application. And it's also low cost compared to a PCT application, which is an international filing application, which you can also file within 12 months of filing an application. So you are ultimately saving both on attorney fees, but also USPTO filing fees. And just ultimately, it helps you get to the USPTO much more quickly, since there are far fewer formal requirements that need to go into a provisional patent application than a non-provisional patent application. And this last part is actually probably the most appealing to most startups and businesses and inventors. The moment that you file a provisional patent application in the US, you can thereafter use patent pending on any covered products that you're putting forth. So this is really attractive from the monetization perspective, the marketing perspective. And so a lot of businesses and companies opt to file provisional patent applications so they can then slap, patent pending on their product until they decide whether they'd like to file a non-provisional application or whatever it might be. So this is a really attractive feature that comes with the provisional patent application as well. But there are some caveats to be aware of when filing provisional applications. And so first and foremost, any information that is not included in the provisional application will not be given the benefit of the provisional filing date. And so it would take the filing date of whenever you convert or whenever you file the non-provisional application. And so you have to be very careful to include all details relating to your invention that are foreseeable and that can, be converted later on to ensure that you benefit from that filing date. Additionally, something that our firm likes to do is to prepare the provisional applications in a manner that complies with the same formal requirements of a non-provisional application. So not only is the conversion process much more easy to do, and there's less gaps that you could ultimately have issues with, but it's also more cost effective. And so if you're drafting a full-blown, very compliant application from the beginning, when a year passes and you can convert to a final application, it's much more cost effective, and you really have to worry less that there might be information that is missing or that you might not have covered the first time around. And then, just from the perspective of business, it's always prudent to consider filing provisional applications, even though you might have non-disclosure agreements in place with third parties. So ultimately, just wanted to quickly walk through a recommended filing strategy as it pertains between the US and the EPO. So first and foremost, we would always advise filing a US provisional application, which is what I just discussed, to help you secure an early priority date. Next, within a year, you can file a PCT application for global protection in a wide number of countries. So it's not limited just to the EPO. There's many Asian countries and Latin American countries. So this is a really global, expansive protection that you can be allotted. And then ultimately, you can pursue US Track 1 accelerated examination for fast results, which I will discuss in further details. So under the US Track 1 route, you were given the benefit of prioritized examination for an additional fee. And so it offers applicants a fast track route to ultimately obtaining a final decision on your application and having your patent issued, often within 12 months of filing. So without the Track 1 route in the US, it's a pretty lengthy process. So from the moment of filing your application for examination, it could take upwards of 2 years to even hear from the patent office. They're very backed up, so it's a very lengthy process. And so we always recommend to our clients that they consider pursuing the Track 1 route, even though it is a little bit of an added fee, because it helps expedite everything and you can hear back within a year. So it's, very advantageous from that perspective. It's especially valuable for startups that are seeking to demonstrate their innovations, commercial potential to investors or strategic partners very early on in their life cycle, because you'll find out sooner than later whether your invention is ultimately, patent eligible. A granted U.S. patent under Track 1 can also significantly bolster your credibility in the market, can help you support licensing efforts, and ultimately provide an enforceable asset while corresponding PCT and European applications are still pending, which often take significantly longer to mature into a patent. So yeah, ultimately it just helps demonstrate value to investors and potential acquirers very, very early on in the process, as compared to a patent application that does not go down the Track 1 route. And so that's just, from that perspective, from a business perspective, this is a really attractive route to take in the US, because again, it can just support licensing and enforcement while your other PCT applications are still pending. And so now just to touch upon how you can coordinate your US and your EPO filings. So a very strategic global patent filing approach often begins with a strong provisional application that captures your core innovations. This early filing, again, establishes a priority date that allows you to further develop the invention over a year, during which time you can pursue the Track 1 route that we just discussed, on a corresponding non-provisional application to obtain rapid feedback from the USPTO, rather than that 2-year window that you'd usually hear within. The examination results and the claim amendments from the US can then be used to refine the claims in a subsequently filed PCT application. So this could help you align with patentability standards and ultimately potentially strengthen the international application. So it's beneficial to understand, okay, what worked in the US, and should I now maybe mirror my PCT or my EP application to reflect what was successful in the US. So you have consistency across your entire portfolio and ultimately just strengthen the international application. So yeah, coordinating your claim scope and your arguments across jurisdictions really just helps ensure a harmonized prosecution. It streamlines examination, and ultimately it enhances the prospects of enforceable global patent protection across the board. So another thing I'd like to briefly discuss is what we call the patent prosecution highway, or the PPH. And so this is an international framework that enables expedited examination of a patent application in one participating office based on a favorable ruling on patentability from another participating office. So for example, if an applicant receives a positive examination result saying, hey, it looks like your application is going to be allowed on a patent claim from the United States Patent and Trademark Office, they can then request accelerated examination of a corresponding application at the European Patent Office under this particular program. So it allows applicants to leverage the work that has been previously done in a first initial office, which again could be the US, and it ultimately helps potentially reduce duplication efforts and shortens examination time and just overall improves efficiency across the board. But to keep in mind, to participate in the PPH, the claims that were filed in the second application, whether that be in the EP or wherever it might be, have to sufficiently correspond. They have to be similar enough to those that have been deemed allowable in the earlier application in the US or wherever it might have been. And so you have to meet specific procedural requirements that have been set forth by the respective offices to make sure that those claims correspond to a point where you could actually pursue the PPH route. And so this is just a little bit of a walkthrough example of how the PPH could come into play. So for example, at a first step, an applicant can first file a patent application with the USPTO. During examination, the USPTO might issue a positive ruling that indicates that at least one claim is allowable. The applicant can then file a corresponding patent application with the European Patent Office, either directly or via the PCT route, to enter the European regional phase. After receiving the USPTO's favorable decision, the applicant can then submit a PPH request to the EPO, which would include copies of the office action that was received from the USPTO, the claims that have been allowed, and a claim correspondence table that shows how the European claims match up to those that have been allowed in the US. If the EPO determines that the claims are sufficiently similar and all procedural requirements are met, it will accelerate the examination process. So again, this can just lead to a faster issuance or resolution of the European application by leveraging the work that has already been done in the US. So now just to transition into a discussion of patent protection specifically in Europe. So as I previously mentioned, Europe varies from US in the sense that in Europe, methods of treatment of the human or animal body by surgery or therapy and different diagnostic methods practiced on the body are not patentable. So this can include surgical techniques, therapeutic regimens. So for example, administer X milligrams of drug Y once daily. It could also include in vivo diagnostic steps. So for example, blood test interpretations that are done directly on the body. So health tech startups in particular should claim devices, systems, or compositions rather than methods of treatment or diagnostic methods, as you will not be afforded patent protection in Europe for those. And again, software patents need to solve a technical problem in a novel way to be considered patentable. So unlike the US, pure software or business method patents are not allowed in Europe. So the software needs to provide a technical solution to a technical problem. The software must also have a technical character. So some examples of patent-eligible softwares in Europe are control systems for machines or devices, or enhanced user interfaces that reduce hardware resource load, or algorithms that improve technical processes like encryption, signal processing, or medical imaging that we just discussed. And so these are some general rules to keep in mind when thinking about protecting softwares, business methods, software-related algorithms in Europe, as the requirements in Europe do differ from in the US. Now, for EPO, patent procedure, and disclosure-related considerations specifically. So the European patent prosecution process begins with step 1, which is a formal examination where the EPO verifies that the application meets all filing requirements. So for example, completedness, correct formatting, and ultimately timely fee payment as well. Once the application is formally accepted by the EPO, the process moves to step 2, which is where you are issued a European search report or an ESR. And this includes a list of all relevant prior art and a preliminary written opinion on the patentability of the invention. So this report is really beneficial because it helps the applicant assess the strength of their claims very early on in the process. So you're kind of getting a sneak peek at what's already out there before actually being examined. So at that point, you can decide whether you'd like to proceed with prosecuting your patent, or maybe it doesn't seem like it's worthwhile. So this is a really beneficial aspect of the EPO patent process. To proceed, after receiving the ESR, the applicant then files a request for substantive examination at step 3, within 6 months of the publication of the search report. During this stage, an examiner reviews the application in detail and considers, again, novelty, inventive step, clarity, and all other substantive requirements to see if your patent is in shape to ultimately, or your application is in shape to be patented. Based on the outcome of that examination, the EPO then either issues a grant decision allowing your patent and issuing your patent, or a refusal at step 4. So if granted, the application can proceed to validate the patent in selected countries, or you can request a unitary patent to simplify coverage across multiple EU states that participate. It is important to note, however, that if none of the applicants or inventors on that particular application are residents or nationals of the United States, and they're all based in a European country, you cannot file a PCT application through the USPTO. Instead, what you need to do is you need to file your international PCT application through the EPO or your respective national patent office. In doing so, you are required to be represented by a qualified European patent attorney or law firm, because in Europe and in the US, only authorized representatives are permitted to act before the EPO on behalf of applicants who are putting forth applications for their innovations. Engaging a European law firm very early on is extremely beneficial because it ensures compliance with procedural requirements, and ultimately it enables the applicant to navigate both the PCT, which is the international filing process, and any subsequent prosecution stages more efficiently. I had alluded to the unitary patent system earlier on in the presentation. And so just to briefly, put forth what that is. So the unitary patent is really beneficial because it's a single European patent right, providing uniform protection across multiple EU member states. And so this is granted by the EPO based on a standard European patent application. So you're filing one application and potentially getting coverage in multiple states in the EU. So ultimately, it eliminates the need for separate national validations in each country or separate applications being filed in each country. And it involves one translation, one renewal fee, and ultimate, centralized management, which is really attractive because you don't have to worry about filing individually in each state. You file once, and then you are potentially, covered across multiple states at once. And so ultimately, it just enables very simplified enforcement through the UPC, which is the Unified Patent Court. But it is important to note that it's only available in participating EU countries. Not all members participate, and so that's a list of the countries down on the slide. And so you are limited to those countries specifically. Fortunately, Romania does participate in this unitary patent system. So it's definitely something to consider. It's a very beneficial and cost-effective route to pursuing protection in Europe. Now to transition into the disclosure discussion, which is really important because the rules in the US and in Europe differ very greatly. And so first and foremost, what is a disclosure? A public disclosure refers to a non-confidential conveying of information that pertains to your invention or your innovation. This can include documents or activities or whatever it might be, but so long as it's not confidential and it relates to your invention and your innovation, it is considered a public disclosure. So some examples of disclosures that can be considered public are trade shows, posting things on the website, having publicly accessible printed publications. So this could be, take the form of having maybe a small journal that you published at some point that you have on a shelf somewhere at a library. Even if nobody checks it out, the fact that it's there and it's accessible to the public is considered a disclosure. And so a really good general rule of thumb in determining whether a disclosure is public is to consider whether the disclosure itself is accessible to the public. So even if the public hasn't actually accessed it, can the public access it? And if that is the case, then it is considered a public disclosure. So some disclosure considerations to keep in mind, especially as you navigate the patent realm in the US versus in Europe. So a key requirement for obtaining a patent is novelty, as we discussed. And so the invention must not be publicly known before the application is filed. In most European jurisdictions, this is an absolute requirement, which means that even your own public disclosure as the inventor before filing can ultimately invalidate the application or prevent you from filing an application. There are some exceptions, however, that we'll touch upon that regard this grace period that we call, so-called grace period that you might get within which you can file an application from the time of disclosure. So some jurisdictions, for example, allow inventors to disclose their inventions without ultimately jeopardizing their future patent applications, provided they file within a specific time window. So this offers limited but very crucial protection, particularly when you might have inadvertently, disclosed your disclosure, or whenever you had a very early disclosure without realizing that, hey, I probably should have filed an application before doing so. So there is jurisdictional variability when it comes to these disclosure requirements. And so ultimately the availability and scope of grace periods differ by country and type of protection. So just a couple of examples. In Estonia and Turkey, there is a 12-month grace period, which is consistent with what we have in the US prior to the priority date. So that's applicable to both patents and utility models as well. In Germany and in the Czech Republic, you have a 6-month period preceding the filing date, but this is only for utility models. Romania also offers a grace period based on both filing and priority dates, depending on the type of protection, and we'll touch upon this a little bit later. From the non-EPO and the international context, there's a 12-month grace period in the US, Canada, Australia, South Korea, Ukraine. So in the US, oftentimes we have inventors or companies that come to us and say, hey, we disclosed 2 months ago. And then, you have a deadline by which you have to file an application because you have a 1-year 12-month window within which you now have to file that application with the USPTO based on the disclosure that you might have had a couple of months ago or whatever it might have been. And so it adds a little bit of pressure on the inventors and the companies, but it's something you need to be conscious of. So EPO-specific disclosure considerations. So for utility patents, the EPO provides a narrowly defined 6-month grace period under Article 55 of the European Patent Convention. But the grace period only applies when the disclosure was either, 1, due to an evident abuse in relation to the applicant, and so, it might have been that you were frauded or defrauded or whatever, it had to be some sort of abuse in relation to you and your innovation, or if the invention was displayed at an official international exhibit. But this is really a narrowly defined exception. There are only very few inventions, international exhibits that actually qualify under this exception. And so it's just best practice to keep your disclosures as close to just as possible. Do not disclose, keep your innovations private until you want to file an application. In both cases, with both exceptions, a supporting certificate has to accompany the initial patent application. And due to its strict conditions, this provision offers very limited practical benefit to most applicants because there are very few situations where you would actually fall within one of these exceptions and benefit from the 6-month grace period. For design patents, however, the European Union Intellectual Property Office allows a 1-year grace period for design registration. So it offers much broader flexibility compared to utility patent protection. So those special circumstances that I had briefly discussed. So again, one special circumstance within which the EPO might allow you to benefit from the 6-month grace period is when there was a disclosure made without consent. So if an invention is disclosed without the inventor's consent, for example, some sort of breach of confidentiality with an employer or whatever it might be, many European countries will provide you with a 6-month grace period to ultimately file your application. But coverage varies, and some countries, for example, Cyprus and Portugal, do not offer this protection. So it's not every European country, but most will offer you protection in this case. The other exception within which you could benefit from that 6-month grace period is when you have exhibition disclosures. So disclosures that take place at international exhibitions can qualify for the grace period if the event is officially recognized under a very specific convention of international exhibits guideline. But we really advise to proceed with caution here because only very, very few exhibits actually meet this criteria. And so while you think you might be benefiting or you might be safe, chances are you probably aren't. So it's a very, very narrow exception in both cases. So we really recommend proceeding with caution. And again, just keeping your invention and your innovation as private and as secret as you possibly can until you are certain that you'd like to file an application. Some additional considerations, even when there is no grace period available, patentability might survive limited disclosures. So in the case of very vague marketing, material or product photos or whatever it might be, your patentability could still survive those situations. And you also have some IP protection alternatives to pursue, such as registered design rights that can still be viable within a 12-month grace period. And this is available in the UK and in the EU. Now, some specific considerations to keep in mind in Romania specifically. So the patent law in Romania provides a grace period of 6 months for, again, the same 2 specific cases that we just said. So 1, an evident abuse in relation to the applicant or its legal predecessor, or again, the invention being displayed at an official or officially recognized international exhibition. So again, these provisions can potentially allow you to safeguard your rights despite an early disclosure under these circumstances. However, again, there are very narrow exceptions, and there are very few cases that will be found to have fallen within one of these two exceptions. So please keep that in mind, and please proceed with caution in relying upon one of these two exceptions. So now to just wrap up with some key takeaways and best practices to keep in mind moving forward. So first and foremost, you should always approach IP issues strategically with a professional European and US council member. So a patent attorney and intellectual property attorney like myself and George can help you navigate any of the complexities that come with the patent process. Be very mindful of subject matter restrictions in the EU. So again, those surgical processes and things of that nature. Focus more on patenting medical devices rather than actual techniques and methods. You should also consider leveraging the speed in the US office and the breadth of the PCT application to help build a very robust IP portfolio. Additionally, keep in mind that absolute novelty remains the rule in most European jurisdictions, which means that any public disclosure by the applicant before filing, even if by mistake or unintentional, can ultimately destroy patentability unless very, very specific and very narrow exceptions apply. And again, there are limited grace periods for exceptional cases, such as the unauthorized disclosure or the recognized exhibitions, but they vary by country and protection type, so pre-disclosure filing is almost always the safest course. And that wraps up the presentation. So you have my information here on the screen. You could scan the QR code and we can connect on LinkedIn if you have any other questions or you'd like to set up another meeting to discuss further. And yeah, I guess we'll turn it over to questions at this point.
Thank you, Amber, for the presentation. Now we'll move on to the Q&A session. So you can send your question in the chat and Amber will answer your questions. We already have two questions.
Yeah, so I see we have a first question here. We're considering patenting our recording system at Action Point, which is already partnered with MSP. Should we first file via OSIM or go directly to the PCT EPO US? So fully transparent, I'm not entirely sure what the OSIM stands for, but generally speaking, and George, you can chime in if you have a contribution here, but I would always recommend going directly to the patent office when possible. And so if you know, for example, that you'd like to just file within the EPO and just remain within the EU member states, I would say go forth with filing in the European Patent Office as soon as possible. And then you could, again, as we discussed earlier, consider correlating that through the PCT application with the US or other countries that you might have interest in ultimately entering, even if you haven't entered those markets yet. And I see we have another question here. What about apps for monitoring different parameters? So for example, biological parameters, location, etc. Would they be eligible for patenting? Yes, so those applications would be eligible for patenting so long as you can demonstrate that there's some resolution that they're putting forth or some technical effect that they have. And so absolutely, we have many clients on our end that we see patenting applications that they then, expand into the international scope with the PCT application. So that's something you can definitely consider patenting as long as you can demonstrate again that your software has some technical effect and solves some technical issue or problem or produces some result that you can actually demonstrate.
We have another one.
Yes. So how do European disclosure rules impact global patent strategy, particularly for companies with both US and EU filings? And so, as I'd mentioned, you have to keep in mind in Europe when disclosing prior to filing that the European Patent Office is much stricter when it comes to the grace period that you're allotted within which you could file an application than the US is. So again, as I mentioned, in the US, from the time of pre-filing disclosure, you have 1 year within which you can file an application. In the EU, that varies. So you might have a 6-month grace period, but there's very limited exceptions. So I would say it's really prudent and a good idea from the very inception of your invention, your innovation, to retain patent counsel and to correspond with a European patent attorney to understand how to navigate this, very complex process, because it is a complex process across the board, and to ensure that you're not publicly disclosing something that might negatively affect your filings later on down the line. So just keep in mind that there are differences in disclosure rules based on where you are. And so while the US might have a little bit of a looser requirement, the European office is far stricter and a little bit less forgiving. So you should proceed with caution in Europe. So the next question is, what is the quickest way to obtain the patent pending status? So again, like I said, in the US, we have a provisional patent application filing, and I believe the European system has something similar to that, which is where you file an application at very low cost, very, loose requirements, just so that you could get something on file with the patent office. Again, get a stake in the ground at the patent office as to what your priority date is and what kind of art can be used against you based on that date. And so that would, in the US, and again, similarly in other countries as well, help you be able to market your product as being patent pending, because you have submitted an application, you filed it with the respective patent office, and from that moment on, you can say that your product is patent pending. I mean, it's truly in an instance. So in the US, we have many companies and startups that come to us and will ask us to file these provisional patent applications. And the minute that it is, they can start marketing their product as being patent pending. So another question is, what are some common pitfalls companies face when disclosing inventions too early in Europe, and how can they avoid them? So again, you just have to be very conscious of the fact that Europe has much stricter disclosure rules and requirements. And so again, it's just really prudent from the very inception of your innovation, your idea, your invention, to retain patent counsel and to keep them in the loop with your process and your invention, and just help them guide your path through Europe to ensure that you, as the inventor, are not doing anything that could harm you later on down the line. It's really a shame to invest so much time and energy and funds into producing something and then, inadvertently disclosing it and not being able to file an application because of that. So best practice to always retain an attorney as early on as possible and to just keep them in the loop through the entire process.
Any other questions? Okay. Thank you, Amber, for sharing your expertise with us today. And thank you to all of you for your participation. We hope you found the presentation helpful and that it gave you practical tips on protecting your research and inventions. We will send the recording, as I say, and the other additional materials to your email. So stay connected with us. More events are coming soon, and have a great day and see you next time.
Thank you, everyone.
Thank you.